I ask you, why is it that every time we, the people, get some minuscule victory, it is immediately torn from our hands? Overnight, the Supreme Court does something absolutely astounding. Something that most don't or haven't put the pieces together on yet. We're going to today. Biden asked Supreme Court to lift limits on contacts with social media sites. The administration's emergency application followed an appeals court ruling prohibiting many officials from encouraging or coercing sites to delete asserted misinformation. This unanimous 3-judge panel of the U.S. Court of Appeals for the Fifth Circuit ruled last week that officials from the White House, the Surgeon General's office, the CDC, the FBI had most likely crossed constitutional lines in their bid to persuade platforms to take down posts about the coronavirus pandemic, claims of election fraud, and Hunter Biden's laptop. Summarized in its conclusion, the panel wrote, ultimately, we find the district court did not err in determining that several officials, namely the White House, the Surgeon General, the CDC, and the FBI, likely coerced or significantly encouraged social media platforms to moderate content, rendering those decisions state actions. In doing so, the officials likely violated the First Amendment. As we covered for you, I'll put a link above so you can watch the video coming off of this ruling from Judge Terry Doughty, memorandum ruling on request for preliminary injunction. The conclusion stating, once a government is committed to the principles of silencing the voice of opposition, it has only one place to go, and that is down the path of increasingly repressive measures until it becomes a source of terror for all its citizens and creates a country where everyone lives in fear. Written by Harry S. Truman. It goes on, however. The plaintiffs have presented substantial evidence in support of their claims that they were the victims of far-reaching and widespread censorship campaign. This court finds that they are likely to succeed on the merits of the First Amendment free speech claim against the defendants. Therefore, a preliminary injunction should be issued against the defendants as set out herein. But you know what they did? They stripped this ruling down slightly. And this is where the Fifth Circuit got involved. File September 8th. Again, major story we did on this. State of Missouri, state of Louisiana. Other plaintiffs against Joseph R. Biden Jr., Vivek Murthy, Xavier Becerra, Department of Health and Human Services, Anthony Fauci, and others. A group of social media users in 2 states alleged that numerous federal officials coerced social media platforms into censoring certain social media content in violation of the First Amendment. We agree, but only as to some of the officials. So we affirm in part, reverse in part, and vacate the injunction in part, and modify the injunction in part. The district court's judge is affirmed with respect to the White House, the Surgeon General, the CDC, and the FBI, and reversed as to all other officials. Now, a lot of people weren't happy about this, but nonetheless, it was still a small victory for we the people. But who oversees the United States Court of Appeals for the Fifth Circuit? It is Supreme Court Justice Samuel Alito. And what happens when it hits the Supreme Court could now impact the very foundation of our Constitution. In the Supreme Court of the United States, Surgeon General Vivek Murthy versus Missouri, the ruling I just showed you, application for a stay of the injunction issued by the United States District Court for the Western District of Louisiana. The ruling will astound you, but there's so much background behind this that I have to bring you to shape in that everything isn't what it appears. And in actuality, both Biden and Trump will stand trial for what impacts what they are stating is the First Amendment of the Constitution. The two will stand trial nearly simultaneously. Wait till you hear the elements of the story, and I guarantee you it's not exactly what you believe it is. Now, my name is Justice Knight. Today, filling in for Lisa Haven. If you haven't subscribed to Lisa's channel, please just take a few seconds to do so. Can't tell you how much that means to both of us. And if you'd like to support us further so we can continue to bring you these messages, please get to restrictedrepublic.com today. So many are moving over because they want their content uncensored, unfiltered, no commercials, no interruptions. And you know where you find that? at restrictedrepublic.com. That's what we created the platform to be. It's like nothing you have seen before. We need you to move over. Make sure you get to Restricted Republic. Join us there. And as a thank you to all of you, because we're going to close off this promotion soon, use discount code INDEPENDENCE. That's $4 a month for 2 years plus 14 days for free. And find out what real news was meant to sound like. Uninterrupted. We are beholden to no one but ourselves and you, our audience. RestrictedRepublic.com. Get there right now. Subscribe using discount code INDEPENDENCE at monthly checkout. But now, let's get on with this broadcast. Application for a stay of the injunction issued by the United States District Court for the Western District of Louisiana. The application concerns, wait for this, an unprecedented injunction installing the United States District Court for the Western District of Louisiana as the superintendent of the executive branch's communication with and about social media platforms. In other words, we want open right and access to the likes of Facebook and Twitter to do whatever we please, but it goes on. Senior White House official speech addressing some of the most salient public issues of the day. The lower court held that federal officials had transformed the private platform's content moderation decisions into state action and violated the First Amendment by urging platforms to remove COVID-19 misinformation, highlighting the risks of disinformation from foreign actors, and responding to the platform's inquiries about matters of public health. The court then entered a sweeping preliminary injunction governing thousands of federal officials. That was the first one I showed you. And employee speech concerning any content posted on any social media platform by anyone. That injunction flouts bedrock principles of Article 3, the First Amendment, and equity. One of my least favorite words. First, respondents lack Article 3 standing. This is what went to the Supreme Court to say, put a stay on this injunction. The Fifth Circuit held that they have standing because their posts have been moderated by social media platforms. But respondents failed to show that those actions were fairly traceable to the government. Now, I don't know if they read the same document I did, but there was many examples of specifically that. And I'm going to show you a few in just a second. Second, the Fifth Circuit's decision contradicts fundamental First Amendment principles. It is axiomatic that the government is entitled to provide the public with information and to advocate and defend its own policies. Of course, the government cannot punish people for expressing different views. That's almost hard to say without laughing. Nor can it threaten to punish the media or other intermediaries for disseminating disfavored speech. But you did threaten to punish social media platforms. Again, an example I'm going to show you. But there is a fundamental distinction between persuasion and coercion. And it goes on and on, so we need to jump in. So what does the Supreme Court, Alito, do? By the way, Alito oversees this court. He throws down a stay. Now, that should infuriate most of you, and I get it. It got me upset at the beginning too, but hold on for one red-hot minute, because there's a little bit more to this story. Politico published, the Justice Department claims allowing the lower court ruling to stay in effect would impose grave and irreparable harms on the government and the public. It asks the Supreme Court to immediately block the Fifth Circuit's injunction placed on the administration while it files a formal petition for the justices to take up the case. Hold that injunction for a moment, because we're going to file with the Supreme Court to take this on. Alito makes a decision within hours. We're going to go ahead and put a stay on the injunction. Under the injunction, the Surgeon General, the White House press secretary, and many other senior presidential aides risk contempt if their public statements on the matter of policy cross the ill-defined lines drawn by the Fifth Circuit. Solicitor General Elizabeth Proligar wrote in a high court filing. CDC officials run the same risk if they accurately answer platforms' questions about public health, and FBI agents risk being hauled into court if they flag content posted by terrorists or disinformation disseminated by covert, malign foreign actors. Where have we heard that line before? The Fifth Circuit's order still seems open to varying interpretations, particularly language prohibiting the officials from acting to coerce or significantly encourage the social media firms to remove, obscure, or reduce the reach of posted protected by the First Amendment. Just look at my Facebook account and you'll see the perfect example of that. And to force various high-ranking federal officials to sit for depositions about their interactions with those companies, that discovery has failed to turn up direct evidence is coming off of Doughty's ruling. The discovery has failed to turn up direct evidence to government officials explicitly threaten the companies with specific consequences if they failed to act on the takedown request. You don't have to go far. Go into the decision by the Fifth Circuit. Read a little bit further. We start with coercion. On multiple occasions, the officials coerced the platforms into direct action via urgent, uncompromising demands to moderate content. Privately, the officials were not shy in their requests. They asked the platforms to remove post ASAP and accounts immediately, or slow down, or demote content when the platforms did not comply. Officials followed up by asking why posts were still up, stating, "How does something like this happen? What good is flagging if it did not result in content moderation? I don't know why you guys," this is government officials talking to social media, "can't figure this out. You are hiding the ball." And then they demanded assurances the posts were being taken down. And more importantly, contrary to what was just stated, the officials threatened both expressly and implicitly to retaliate against inaction. I don't know how much clearer it could be. Officials threw out the prospect of legal reforms and enforcement actions while subtly insinuating it would be in the platform's best interest to comply. And as one official put it, remove bad information is one of the easy, low-bar things you guys can do to make people like me, that is White House officials, think you're taking action. And this goes on and on, but that wasn't the only portion of it. Here, the officials made express threats and at very least leaned into the inherent authority of the president's office. The officials made inflammatory accusations such as saying the platforms were poisoning the public and killing people. The platforms were told they needed to take greater responsibility and action. Then they followed their statement with the threats of fundamental reforms, like regulatory changes and increased enforcement actions that would ensure the platforms were held accountable. Beyond express threats, there was always an unspoken or else. The officials were not shy to allude that understanding native to every American. When the platforms faltered, the officials warned them that they were internally considering our options at the White House as to what to do. And we have shared these concerns with the highest, and I mean highest levels of the White House. And the president has long been concerned about the power of large social media platforms. The letter deployed in the officials' campaign reveals clear plans to punish the platforms if they did not surrender, which flies in the face of that very statement. So how does Trump enter the scene? It was actually off an old ruling. If you remember, they had said that Donald J. Trump, at the time president, had used his Twitter account and banned other social media users in violation, potentially, of the First Amendment. The Supreme Court, however, threw that case out. Well, now two more comparable cases are headed directly to the docket. The justices agreed to hear a pair of cases on what the First Amendment has to say about social media accounts maintained by elected officials. The Supreme Court agreed on Monday to decide whether elected officials violated the First Amendment when they blocked people from their social media accounts. The question has divided the lower courts and had seemed headed to the Supreme Court after the Federal Appeals Court in New York ruled in 2019 that President Donald J. Trump's Twitter account was a public forum from which he was powerless to exclude people based on viewpoints. Now put that into consideration on what is happening with the Biden administration. It gets a little nerve-wracking of what the Supreme Court may decide, doesn't it? We also conclude that once the president has chosen a platform and opened up its interactive space to millions of users and participants, he may not selectively exclude those whose views he disagrees with, because the Supreme Court now takes on social media cases that echo of this Trump case. And they will decide. 2 years ago, the Supreme Court dismissed the case over Trump's efforts to block critics from his personal Twitter account. A lower court had said Trump violated the First Amendment whenever he blocked a critic to silence a viewpoint. But the Supreme Court said the case should be dismissed because there was nothing left to it after Trump was permanently suspended from Twitter and ended his presidential term. So this will be the first time that a seated president will face a comparable charge using that office to silence the viewpoints, the First Amendment rights of we the people. 2 presidents accused of the exact same First Amendment infraction. Although from different perspectives, the Supreme Court is soon to rule, because Biden will still be in office when this case hits, or these 3 cases hit. 2 that echo exactly what happened to Trump, and 1, at least, that will be directly pointed at Biden. And we are about to see if our First Amendment rights will stand or government overreach will prevail. We will keep you posted of all the developments in this case. I love you all. Until next time, Godspeed and God bless. Justice Knight, signing out.